Christy, I'm going to start with, I think, probably what's top of mind for a lot of our attendees today, and that is the upcoming H-1B cap season for the fiscal year 2024. So right off the bat, Christy, when does H-1B cap start?
Well, that's a really great question, Eric, because I know a lot of our clients are really excited. By way of background, for those of you who don't know, H-1B is the most commonly held visa out there. So it's one where if you haven't yet held it, you're going to be subject to a numerical quota. And so there is a quota of 65,000 visas for regular numbers. And then for those, there's a special carve out for those with US master's degrees or higher. So for your employees who've never held it, now is the time for us to consider them for the lottery. And USCIS did recently roll out sort of what we call the registration period. So from March 1st through the 17th, companies and attorneys will be able to log on to the My USCIS account and register folks for the lottery. By, I'd say, the first week of April, we will then be notified by the Immigration Service which of those employees have been selected for the lottery. We'll log back into the My USCIS account. We'll be able to see which ones have been selected on sort of the selection notice that USCIS indicates. They talk about you have a 90-day window to file. And for those that have been selected, we and many of your law firms will certainly file within that window. And if all goes well, come October 1st, your employees will then be able to start working in H-1B status. So that's really good news. It's crazy. We're February 2023 and we're talking about start dates in October, but now is the time to plan. And for those of you in the call who are thinking about registering folks and haven't yet considered, I would say you still have a little bit of time. Be sure to reach out to your law firms and let them know, look, you have employees that you still want to enroll in the program. It's still feasible. But after March 17th, that sort of window closes and you're not going to be able to add anybody to this year's lottery. So if you haven't yet started, think ahead and plan ahead so that you don't miss out on the opportunity for your employees to get an H-1B this year.
Well said, Christy. And yeah, did see those timelines come out. And that's all available on USCIS's website as well, correct? That people can just go and look at.
Absolutely, yeah. USCIS has a pretty robust website and they'll let you know the windows for when the registration period is.
Cool.
But I would say law firms.
Yeah, totally. So Christy, I know you and Addie have both mentioned that you've been in the space for a little over 20 years both. And I'm sure you've seen how the H-1B and just immigration has changed over the years. And in particularly, there was a time, I would say, 2018, 2019, 2020, when USCIS was introducing electronic registration, and there was, that other potential big change. But it seems the last few years have been relatively the same, to put it, in one way. But I'm curious, has anything changed for this upcoming H-1B cap season compared to years past?
Well, that's a good question, Eric. What I would say is, in the last 2 years, USCIS has certainly changed the way we file H-1Bs. Prior to 2021, when we talked about cap seasons in years past, the way it worked was immigration law firms would file hundreds, if not thousands of cases by April 1st for all their clients. And so we would make a mad dash, work through the first half of the year, file cases by April 1st, and we would never know whether or not an individual was selected. And if you were, you would get a receipt notice somewhere after filing, after April, sometime in the May, June timeframe, we would get a receipt notice. And for those that weren't selected, by late summer, we would get tons of petitions returned back from USCIS saying, so sorry, weren't selected, try again next year. And I think the last 2 years, it's been really great because USCIS is really streamlining the process and they're finding a way to make this process a lot easier. So in 2021, which was fiscal year 2022, USCIS started the registration process. So in that first year, when they rolled out the program, they had not only one round of the lottery, they actually had 3 rounds in total. And I think a big part of it was they hadn't received sufficient numbers for reaching that 85,000 quota that I mentioned earlier. So they conducted 3 rounds, one in April, one in July, and I believe one in November. And so they did receive sufficient numbers and it was really successful. But this past year, we saw that USCIS did decide to still continue with the electronic registration, but this time around we saw them doing or doing one round, and in that one round they had received sufficient numbers for the lottery. And I think every year as they're perfecting this new system, it's going to get better and better. And so this year, as we start rolling out registration, one of the things I would say is I think our prediction is they're probably going to have one round of the lottery. I think the economy being what it is, we might have fewer registrants overall. That still remains to be seen, because I think we're going to see what the numbers are going to look like. They'll post the numbers and the results after registration. But because companies might be a little bit more discerning in terms of who they may or may not register, you might see fewer registrants. But overall, the process is going to be the same. We're still anticipating one round, but if they don't get enough numbers, you could see a second round or a third round. But I think unlikely, because I think they're sort of perfecting the system. But what I would say is this process has made a huge difference. I read somewhere that USCIS has found this process to be extremely easy to use, and they even cited, I think, their rating of 4.84 out of 5 for this program. So they're touting their own success rate in terms of how great this program is. And we have found on our end that it's fairly easy to use. And it's really nice to be proactive and be able to know by April whether or not your employees are selected for the lottery versus not knowing midsummer or end of summer. So hopeful that this continues on and stays consistent. And I think that'll help a lot of companies plan ahead if for some reason your employees aren't selected for the lottery this year.
Yeah, I like Christy. I like how you brought up the rating of the electronic registration system. I feel, playing into the cliche of, we never like things with the government, like it just never works. And so the fact that, it's like a 4.8 out of 5 the last couple of years, it speaks a lot to electronic registration. And then just to confirm, so this was an audience or a registrant question from before the live session started. Will there be multiple lotteries this year? But it sounds like you don't think there will be, just the one.
Yeah, I can add in that. Yeah, it seems like there probably will just be the one. They always had accepted more petitions, even in the past, accepted more petitions than were allotted, knowing petitions would be denied, knowing that that sort of stuff happens. So I think the first year we saw the registration, or it was the second year through the registration process, they did the second or the third lottery because they didn't pick enough in the beginning. It's so much easier to register for an H-1B now than it was in the past, that you do get a lot more people registering, and maybe they're not sure about it, but it costs $10 if you're registering on your own, so a little bit easier. So you're getting more people. So I think that it had more numbers of people maybe being getting selected, but not actually submitting a petition. So I think they've accounted for that last year, and probably even more so this year with more data.
Christy and Addie, next couple of questions from registrants and attendees. What constitutes an H-1 dependent employer?
So what I would say is H-1B dependent employer is, in a nutshell, a company that sort of relies heavily on an H-1B worker. There is a formula depending on the size of the company. And so what I would say is, as we are exploring H-1B cap season, as you're adding potentially new H-1B numbers, I think it's good to go back and look at your program to figure out where you sort of lie with dependency. And the formula goes as this: if you have less than, I believe, 25 full-time employees and 8 or more are H-1B workers, that is deemed a dependent employer. So if your numbers are 26 full-time employees to 50 and 13 employees are H-1Bs, you can be deemed as an independent employer. But for a lot of companies that have 51 full-time employees or more, the Department of Labor looks at sort of a percentage. So if it's 15% or more of your overall US population is H-1B, then in that instance, you're deemed to be a dependent employer as well. And I think the thing to watch for is, as a dependent employer, you're sort of subject to more scrutiny by USCIS and the Department of Labor, and there are additional obligations and attestations that you have to make. And really what it comes down to is you want to make sure that you're not displacing US workers. There's recruitment requirements showing that you didn't displace US workers 90 days before and 90 days after. But one way that companies can show that they're really actively doing this is if they tend to hire what we call exempt employees. And so if you have individuals who have US master's, not US, but master's degrees or higher, and you're paying them a certain amount of money, I believe it's 60,000 or more, then I think in that instance, that individual would be deemed as an exempt employer. And as such, you could, move forward with an H-1B for these folks, but what it does do is it avoids sort of some of the obligations and attestation requirements that you have to make by not displacing US workers. And the way it comes about, or what I would say is the way it's sort of defined, is when you're preparing what we call the labor condition application, which is part of the H-1B process. Companies have to make attestations as to whether or not they're dependent, whether they're in compliance, and on the forms themselves, you kind of have to indicate these boxes. So if you're not sure, whether you are or not dependent, reach out to your attorneys so that they can better help assess. And, for companies who are sort of borderline in that 12, 13% and may not necessarily want to make those additional attestations, it's a good way to sort of plan around your program and, see how many more additional H's that you'll have to kind of not get to that 15% of dependency. But those are things to note. It's, we have several companies or clients who are dependent. It's just added scrutiny and just making sure that the I's are dotted and the T's are crossed, just for added safety measures to make sure that you are really actively recruiting out there for U.S. workers and not displacing those U.S. workers.
Totally. I'm curious, Christy, you mentioned, there is a set allotment for H-1Bs and highly sought after employment visa. Like you said, that only the 85,000 total are available. What are the reasons, or have you seen any reasons on why an employee or employer might pass on the H-1B lottery?
So for a lot of international students, I would say that they're starting out in their careers. Some may decide, hey, I loved going to school here, but my future lies elsewhere. So you could have employees deciding, you know what, I want to work on my OPT STEM, OP2N leave, and that could be a reason why they don't necessarily pursue an H-1B. F1 students are also FICA exempt, so they're not subject to the Social Security taxes. And so if you have an employee who's really tax savvy and may not necessarily want to pay for some of those other taxes, they might decide to stay on F1 for as long as they can before they need to switch over. And I think the other bit of it is, I would say, if you have employees already working for your company on other recognized visas, I know we're sort of focused on the H-1B, but there's a whole slew of other visa categories, from the TN to the O1 to the L1, and even some dependent visas. So those have ample time too. So because those employees can work for respective companies and they're not in jeopardy of losing work authorization, then what I would say is they're less inclined to sort of pursue that. From the company's perspective, I would say that, a lot of companies are cost conscious this year. If they do decide to move forward, they might only want to move forward with critical employees versus the ones that they're not as, that have other forms of work authorization. So they might just push forth with the cases that are truly critical, and the ones that aren't, they can wait for the following years. And I think the other thing I would say from a company perspective is that the last couple of years with COVID, people couldn't bring folks in the U.S. with the travel bans and the delays at the embassies and consulates, that people have hired folks outside the U.S. And since they're situated overseas or happy overseas, maybe there isn't a high demand for H-1Bs because they have the talent that they want, but they're not necessarily situated in the U.S. right now. So I would say those are some of the reasons from, I would imagine, the company's perspective, as well as from the employees, from what we're seeing.
Interesting, definitely. Speaking of consulates, do you have any news regarding the State Department pilot program that will allow certain H and L visa holders to renew their visa stamp in the United States rather than abroad? I believe this news is from earlier this month. Bloomberg Law broke the story, I believe. I guess first to start, Christy and Addie, can you provide just a context on what this question is referring to?
So what I would say is, individuals who are in the U.S., if they do travel outside, there is a sort of a requirement to get a travel endorsement at the embassy or consulate abroad. outside of Canadian citizens, citizens of everywhere else in the world will be required to obtain valid visa stamps in whatever category that folks are coming in. And I think in the last couple of years, the challenges with travel bans and consulate closures due to COVID has been really, really challenging on a lot of companies and families, because if embassies were closed, then it would be challenging to obtain visa stamps abroad. And so one of the proposals that we're seeing with the Department of State is this demand for talent and having them come into the US and be able to travel easily. So one way that the Department of State is now exploring is, look, the folks that are in the US who've previously obtained visas are very low risk. And so if we can find a way to clear out our backlogs and help kind of move the needle with these folks and get them visas to help them, travel and live their lives freely, we'll try to do what we can. So I think reinstating what we call the visa renewal process in the US is not new. It's something that they did years and years ago. So when Addie and I first started practicing many, many moons ago, they still had this process. What this process was folks would be able to take their passports, submit their documents to the Department of State. 4 to 6 weeks later, we would get the visa stamp back in the passport for our clients. And so, Department of State is now foreseeing something similar to that, and they're planning on doing a stateside program and a pilot program at that, seeing whether or not it's first extended to, I think, H's and L's, and if it does really well, who knows, they could probably expand it out to other visa categories. That Bloomberg article, right after it was published, we got tons of emails and calls from clients saying, hey, can I submit my passport to the Department of State tomorrow? I don't want to travel. I want to get my visa stamp before I come back in. But we were like, it's great news. We just need to wait. And at the BAM conference last week, there was a panel. It was called Washington on the West Coast. And Julie Stuft, who is the Deputy Assistant Secretary from the Consular Services Office, she actually attended. She spoke on that panel and confirmed that very much so they're moving forward with the program. When we sort of pushed her on whether or not she could confirm a date, they said that they couldn't confirm an actual date when they would roll out with the program, but very much so that they're working towards it on the back end. They want to ensure a successful program, so they don't want to prematurely give you a date where it's not going to be rolled out yet. But this is certainly a situation that we're going to be monitoring very closely, because I know many of our clients and many of you probably on the call would be very interested in what this means. And I think it affords employees and companies a chance to plan ahead. So if you know that you can apply for your visa stamp, not have to book anything, have a visa in hand that's valid, that it doesn't expire, then you can plan your trip, go enjoy your family, enjoy your vacation, and then be able to fly back and not have any of those considerations and concerns about being stuck abroad. That's going to be huge for a lot of employees, and just certainty for companies and planning around staffing for employees and projects, and not having employees kind of stuck outside the US. So this is going to be a huge advantage, and we're sort of excited to see where that goes. But as of now, we still don't have a date, but we're excited to see what this means for a lot of folks moving forward.
Great, thank you so much, Christy, for addressing that question. So moving along, want to open it up to some more like general immigration and mobility questions for you, Addie. But as always, Christy, if you want to chime in as well, feel free. So Addie, we did get a couple questions. I'll read them. They are similar, but I'll read both of them just so our attendees can hear them. So when screening applicants for possible employment, what can and can't we ask about the candidate's authorization to work in the United States? And then similarly, at what point in the hiring process are we allowed to ask them about needing immigration sponsorship? How should we ask? What documents do you recommend we collect at the time they start employment regarding immigration status?
Yeah, absolutely. This is a question that that we get a lot. And just for, kind of zoom out, big picture, like why is this important? And it's important based on discrimination, right? You don't want to be discriminatory in your hiring practices. So obviously immigration is essential. If you need to sponsor somebody for a H-1B or for something different, then you obviously need to know about that. So the two questions, there's two questions really that special counsel has said, look, these are the questions that are appropriate, and if you stick with these questions, you're not going to be deemed to be discriminatory in your hiring practices. The first question is, are you currently eligible to work in the United States of America? And then you always have to ask that second question, which is, do you now or in the future require visa sponsorship to continue working in the United States? Okay, so if you get a yes to both of those questions, are you authorized to work? Yes. Will you now or in the future need sponsorship? Yes. At that point, then you can ask additional questions about, well, what's the basis of your current work authorization? When does that work authorization expire? And you can open the door for inquiring about whether or not, you know, there are a means for the company to sponsor them.
So follow up to that, when it comes to sponsorship and requiring immigration, how does a global mobility specialist consult their HR team or an HR team on immigration?
You know, you're working together. We talked a little bit in the beginning about collaboration, right? So internally, you know, you have to look at your company's process. What is your hiring process? Where are these questions asked? And are the answers to those questions getting to the right people? So if the hiring process is starting with the recruiters, do the recruiters have an open window and an open dialogue with HR and or global mobility, right? Who's ever managing that immigration? What is that process in your company? And then making sure once you're aware of that process and who's actually asking these questions, that's where there's room for the collaboration. I mean, so many times, you know, Christy and I have been doing this for a long time. So many times we've seen situations where they get through the initial screening, right? And then they go to fill out their I-9, right? You're asking these questions, then they go to fill out their I-9 and they're like, oh, actually, I need an H-1B, right? So, and these questions are pretty vague. The questions up front, they're fairly vague. And so sometimes people might be answering the questions in the way that makes it seem like they have work authorization or they don't need sponsorship, but they actually do. So it's just opening that communication, making sure your recruiters have enough information to know when to ask those questions. So I think it's really working internally, you know, with your team and opening up those channels of communication.
Totally. So next question is on general immigration and mobility. Addie, I'm curious to hear your thoughts on if you're seeing trends for governments around the world to digitize for filings of immigration processes. So we'll start there, and then I have a follow-up.
Yeah, I would say that if most of the people on this call are in the United States, that the United States is very, very behind. Most countries are digitizing the immigration process. I spoke with our counterpart, Jim Yang, with Envoy in Canada, and 85 to 90% of the immigration applications that are filed are digitized. So the U.S. is certainly behind. I think that there's multiple reasons why, and we're moving in that direction. We're just a lot slower than some of the other countries.
In your opinion, what are the pros and cons of how digitization will have, for current immigration practice?
Sure. I think there's a lot of pros. I think we've seen that with the H-1B registration and the H-1B lottery, right?
Mm-hmm.
Before, a few years ago, we were preparing an entire H-1B petition. We were attaching checks. Companies were paying, $3,000 in government filing fees and sending those off to the government. And they're getting, 200,000 petitions, and there's only room for 85,000. That is a significant waste of money and a significant waste of efficiency. So I think this registration process has really helped with the efficiency. I think we also see it in the Department of Labor perm, right? Perm is submitted online, and now when you get an audit with your perm, you're submitting your audit online, right? Within the platform. So I think that we have units that are working on that, and hopefully it continues in that direction, because I think it does help with efficiency. You know, we still today sending FedEx packages. It's been more than a few years, pre-COVID for sure. We used to do field trips, and we would take our clients on field trips, and we visited the California Service Center
Right.
in Laguna Niguel. We went down there and they gave us a tour. It was amazing. This is when USCIS had a little bit more customer service and client service, and really wanted the public to come in and be a little bit transparent in their processes and how they work. So we toured around the California Service Center operations, and when we saw the mail room, we were all kind of like gasped, right? Like there's like these big FedEx trucks, and then they're like just pulling in, you know, all of these packages. And I think one time someone saw like a package dropped like in the crack of the truck, like there was a crack and like a package dropped when it was loading, and it's like, oh God, don't be my H-1B petition, right? Like things get lost when you do things by mail.
Mm-hmm.
Of course, that also happens electronically too. There can be issues. So I think that as long as it is rolled out in a responsible manner, then there's, you know, not as many cons as the pros here on digitization. I think we've also had some experience during COVID where USCIS workers couldn't come to the office. They were working remotely. What they were doing is we would file a petition, they would scan it, and then the scan would go to the officer, you know, at home. They would have access to it and they would do the reviews. Well, we were noticing RFEs for someone's passport page or for, you know, the annual report. And so it seems like in their process of scanning, they were dropping off pages from the petitions, and that was creating delays, and it was creating RFEs. So I think as long as the planning and the process of the digitization is done in a responsible manner, that it's a good thing.
Agreed. Addie, next question from a registrant. Ran it by you ahead of time, so this question is, we are located in Indiana. We want to hire a Canadian to work at our Canadian location. However, there will be regular travel to the US. Is a visa necessary for the travel? And if so, what kind of visa should we look into?
Yep. So this is a great question that you're going to want to go to your immigration provider, to your law firm, and ask, and then they're going to come back with some questions. It's really all about what that individual is going to be doing in the US. There are two factors. What are they going to be doing in the US? But then also, how often are they going to be coming into the US? If they're coming in and it's just business meetings, they're just coming in for business meetings, you can do that as a visitor, no work permit needed. But if they're coming in frequently, you know, many times a month, and they're staying for 2 weeks at a time, and then they go back to Canada for just a few days, and then they come back for a few weeks, then we might want to look into what type of work permits would they be eligible for, because on that frequency of travel, they could get questioned by the officer, and you'd rather be prepared with a work permit if there is any determination or there's any interpretation that maybe they're working in the US, then you want to be prepared with that work permit. Canadians are eligible for the TN, which is under previously NAFTA, and there's 26 different occupations on the list of those that they could qualify for. So that would be really the first step, is looking to see if they're doing one of those occupations. Are they an engineer? Are they a computer systems analyst? You know, sheep herder happens to be on there. Are they sheep herder? But many different occupations on there. So we would look at that list. You would want to look at that list first, see if they qualify, and then that TN could be an option for the Canadian citizen. If they worked for the company in Canada for at least a year, then they could possibly be eligible for the intercompany transfer, and that can be on an intermittent basis. So they could come in and out on the L1 intermittently. So those are just two options after you've kind of gone through that assessment process to see what's needed.
Great. Thank you so much. So looks like we'll move on to our next section. Do want to be aware of time. So Addie and Christy, we're going to shift to more like government updates, things that have come out from USCIS since the start of the year. I think the biggest one, or the biggest news item that we received a lot of questions about is the proposal from USCIS to increase filing fees. So question for both of you, do you think I guess actually first let's take a step back. What is the proposal and what filing fees are we talking about?
USCIS published updated fees, I think recently. The comment period, I believe, for USCIS is early March. So there are fees that are being proposed across the board for different categories. And in essence, to fund the department, they're sort of wanting to help reduce backlogs, and they're finding that increasing the fees and being able to use that to staff adequately to reduce the backlogs is one way of looking at it. I think the challenge is, though, when you're looking at each increase, some are nominal and others are really, really high. And I would say that for business immigration professionals, I think the I-129 is the form that we use for all the various work visas for the most part. And right now, the baseline fee for H-1Bs are $460. But under the proposals, it's going to vary depending on the category that you're asking for. So when I was looking at the fees, I think a couple, early when they were proposing it, it was really, really high. So for H-1Bs, they would go from $460 to $780, and that's a 70% increase. For L1s, it would go up to $1,385, and that's a 201% increase. For O1s, you're looking at $1,055, which is a 129% increase. And TNs, what Addie just mentioned for that particular scenario, you're looking at a 1015, which is a 121% increase. So, for a company who's sponsoring visas and you're sort of paying a similar fee across the board for all visa categories, and now with the proposals of potentially fees doubling, if not getting higher, I think the challenge is it's going to make companies pause to think, do we really need to hire these folks? Do we really want to sponsor visas? I think the way we sort of look at it is, companies are hiring individuals on visas because there's a shortage of talent that they need. Companies aren't going to spend all this money unless they absolutely need to. And so I think that the increase in fees is a little bit daunting because it's going to hit their budget a lot more. What I would say, though, is we're in the notice and comment period. It's an interim rule. It's not a final rule yet. So it's not as if it's going to hit companies' budgets tomorrow. I would imagine because of the fees and the increase in the fees that we're going to get tons and tons of pushback from companies, law firms, stakeholders. And, it is the Federal Register will take all the comments that's sort of submitted and go back and look at, the fees that they've increased. So what I would say is, even though there's all these proposals for increased fees, it's likely to hit, but what is being proposed may not necessarily be the fees that will actually take effect. So before you sit here and get stressed out about, oh my goodness, we have to go back to procurement and let them know, or the finance department to let them know that our fees are going to double in the next couple months, that's not necessarily the case. So what I would say is, try not to panic. It's something that we're definitely watching. It's good to know. I think as you're forecasting or budgeting, put in some assumptions and maybe put a note for those financial folks that, hey, there may be some budget increases. And if it does hit, we'll be notified well in advance of when that happens, and we'll be able to kind of pass that information along to our clients and the folks out there. So I would say, wouldn't panic yet. I think historically in years past, when they did have slight fee increases from the notice in the Federal Register to the actual implementation, I think it was like 4 to 6 months. So if we are going to see any fee increases with very little objection, then it might happen Q3 or Q4 of this year, but nothing yet. And because the fees are so high, I would imagine that you're going to get tons of pushback. 140 fees weren't so high, it would go up from 700 to 715. And Addie just mentioned, registration. You're going to see a lot of folks registering individuals, because right now that legal fee from USCIS is $10, but under the proposals for next year, potentially that goes up from $10 to $215. So it's a sizable increase. So if you're going to have to now spend $250 versus $10, you may not want to register, folks. So that's something that companies are going to have to weigh. But don't panic yet. We still have to wait and see what it really comes out with, but it's good to kind of plan ahead and know what the possible fee structures could look like.
So Christy, interesting, and you mentioned, obviously don't panic yet, plan ahead, let the teams know. How might someone communicate or prepare, let's say, their senior leadership potentially for this increase in fees related to immigration petitions?
I would say for our firm, one of the things that we do with our clients is, at the end of the year, our clients are always asking us to help budget forecast for them. And so, depending on the size of the population, we sort of work with our clients to help them kind of project what the fees are, in light of government processing times, whether it's the USCIS or DOL. And so we sort of help clients kind of plan ahead for their budgets for the following year. And this is one way in which you can kind of potentially incorporate the assumption that I mentioned and add that to part of the budget. So I think it's important to communicate it, but if it doesn't hit, that's fine, but at least give those that need to know kind of what that possibility is. I think for a lot of companies, they sort of budget forecast. This is their set budget for the year. If they go beyond that, I know that companies get really upset because they've exceeded their budget. So if if you're not sure yet and there is a possibility that this could hit your budget, maybe factor these fees in. And if it doesn't hit your budget, at least, you're not going to necessarily have to go back and ask for more. At least you have a huge enough wiggle room so that if the budget does increase tremendously, you'll be able to account for that. But work with your attorneys, work with your law firm, work with your finance and billing department, because it is very much in collaboration. As Addie mentioned, we work together to kind of come up with a plan. And if you need sort of support, leverage from your law firms, they'll be able to sort of assist you in kind of helping to communicate that with the powers that be that need to kind of understand this information.
Great. Thank you so much, Christy, for that. Final question in this section, and then we'll move on to some live audience questions that have been coming in. Addie and/or Christy, what updates do you have on reducing green card backlogs?
So probably not any good updates. Mostly that the backlogs are going to continue. So that question could mean two things. One, the backlog of priority dates. So that's one aspect, and those are expected to move. That's the individuals born in India, individuals born in China. The eligibility to actually finish that third step of the process, the actual green card application, is backlogged. It moved fast last year. There was a large jump where many people were eligible to file that third step, and then it went backwards. We're expecting that to slowly continue. The visa bulletin comes out every month. Slow movement. We're not going to probably see a big jump like we did last year. Slow movement to the end of this fiscal year. With regard to the long processing times that it's taking to get through the PERM process, which is the first step of the green card process, unfortunately, we see that continuing to take longer. That first step of the PERM process, the prevailing wage, is taking up to 12 months now, where it used to take 4 months. It's now up to 12, and then the actual processing of the PERM application, which was also around 3 to 4 months a while back, is up to around 8. So we're not going to probably see a whole lot of movement in that. There was a immigration bill that was proposed late last year I think we had I think we talked a little bit about it on one of the previous webinars. Didn't pass, which wasn't that much of a surprise. But in that bill was a provision to make the Department of the PERM process, or the prevailing wage process, make it fee-based. So you would pay a fee, which would give the Department of Labor the income to maybe hire more people and make that process faster. I don't think, unless something like that passes, that we're going to see a whole lot of movement on the prevailing wage of the PERM.
And speaking of other legislation, there's always bipartisan support for what we call recapturing unused visa numbers. And so there's always bills that are being introduced in both houses. There hasn't been much traction. We do know of bipartisan support for both, because you're not creating new numbers, it's using those numbers that weren't allocated in years past. And so there's always support for that, but there hasn't been much traction in those particular bills. But if it's an add-on to another bill, maybe we'll see some sort of movement there. But that could be another way in which sort of moves the needle forward for cases and get them adjudicated faster. So there's always bills being introduced, whether it's to recapture unused numbers, and or there was one, I think there was the Relief Act, that was a bill in the Senate that sort of proposed increasing the number of employment-based cases. Not much traction right now either. And keep in mind, bills are just being introduced. It doesn't become law until the president signs it. But what I would say is, as they're being proposed, these are considerations to be had, nothing finalized. And so Addie is absolutely correct in that. Unfortunately, there's not a lot of movement. It's things that we have to watch for and kind of plan ahead. But just know that this is one of the challenges in the immigration front, and that there are significant green card delays.
Got it. Great. So we are almost at the top of the hour. Addie and Christy will end with some audience questions that have come in since we started this session. So Addie, you're just talking about the PERM process and that taking longer. This individual wants to know, and I'll tie it in. There's a couple more questions regarding macroeconomic conditions that we've been hearing about the last couple of months. But how do layoffs impact the PERM green card process?
Sure. So when you file a PERM application, keep in mind, well, when you start the green card process for someone through the PERM process, keep in mind the big picture of that is that there are no qualified U.S. workers for this position. Therefore, I want this foreign national to fulfill this position, and they meet the requirements of that position. So if you're thinking about it in those terms, which is what the PERM is, it's a test of the labor market. If you've laid people off, then can you really say that you can't find a U.S. worker for that position, right? So it's certainly position and location specific. So if you have a layoff, you have to look at your PERMs that you have in process. When you submit a PERM, you attest that you have not had a layoff in that position or that location and location for a similar position in the last 6 months. So there's really two aspects that you're looking at when you have a layoff. Do you have PERMs that you're supposed to file in the next 6 months that there were similar positions impacted? And then two, if you have an active PERM program, are you recruiting for positions that you laid off, right? And how does that look to your company? How does that look to the people that were laid off, or how does that look to the industry? So those are really the two factors that you need to address when you have a layoff.
Great, thank you for addressing that question. So in relation to the macroeconomic trends, this individual is asking, what can tech companies do to prepare corporate immigration programs in light of the macroeconomic conditions for the tech industry? Should we be expecting additional scrutiny on petitions, higher risks, more audits, etc.? I guess, Addie, we can start with you, and then Christy, if you want to chime in.
I mean, that's a great question. And there are, you know, USCIS and immigration, it does go through waves, right? Certain waves. We haven't heard or seen, I don't think in our practice yet, any impact there yet. And I don't necessarily think in the past, I mean, we've gone through this before in the past. If a company has, and we've certainly had this as well, you know, massive layoffs, yes, it can absolutely subject your perms to a little bit more scrutiny and perhaps some audits. So I would expect that if you're a big company and you're in the news and you've done a big layoff, you know, you really need to prepare for any of those perms that you need to file, and consider waiting that whole 6 months before submitting any applications. So yeah, and as far as, you know, H-1Bs and Ls, I don't think we've necessarily seen big pushbacks based on layoffs in the adjudication of those petitions.
I would agree with Addie's assessment there. In terms of USCIS filings, we're not going to see, you know, high level scrutiny, but as it pertains to the perm application, because there is that labor market component, you know, one of the questions I get asked a lot is, Christy, our company hasn't had any layoffs. We're ready to file these cases, but will I expect an audit? Will there be supervised recruitment? Because all of our competitors have had layoffs. And so that could be a possibility. I think the good news is we haven't seen an uptick in audits, and the way the perm application works is you file the application. If the Department of Labor has additional questions, they'll come back and issue an audit. So for a lot of the cases that we filed, even in industries where we have seen layoffs, for our clients that haven't had impact, we're still getting cases approved. But I wouldn't be surprised if we might see an uptick in audits, but we haven't yet. And part of that is sort of the assessment as to whether or not you actively recruited, you provide the documentation that the company went out there, did the advertisements from the state workforce agencies, all the various forms of recruitment that were conducted. So I think in that instance, so long as you can document that you actively recruited, were able to disqualify candidates, haven't had layoffs in the area, you're still fine to move forward. You still get the case approved. Unfortunately, an audit will trigger a delay by, I'd say, 6 to 8 months afterwards, but it's not impossible to get cases approved. We might see more scrutiny on the perm front. On the non-immigrant side, not as much. We might see the USCIS resume with what we call FDNS site visits, but that's not because of layoffs. It's just verification of data as it pertains to the petition. So if a company files a case, USCIS wants to make sure the employee is working with you, works at that work site, they can easily conduct a random site visit, but that isn't necessarily triggered by a layoff. It's just the verification of the data. So what I would say is we're not going to see that much on the NIV front as we would the perm application.
Great, thank you both for addressing that. Final question as we approach the top of the hour. Christy, start with you, and then Addie, if you want to hop on and chime in. How do you think about servicing small startups with immigration needs that are very different than large companies?
I think one of the advantages of being in this industry for 20 years is we've worked with all sorts of clients. We've worked with startups, mid-range clients to the Fortune 500, Fortune 100 companies. It's true, every client has their respective needs. I think it's important to leverage from a service provider, a law firm that is able to address the specific needs of startup companies. There may not be the infrastructure in place with startup companies. You've got funding issues. Providing the documentation for ability to pay is very different from a publicly traded company that has a 10K in an annual report. So it's not impossible. I think what it is leveraging from your immigration provider to help sort of strategize and assess some of the concerns with you. There are special challenges, I agree, but it's not impossible to get through, whether it's the non-immigrant visa processes or the perm application. It's completely doable. I think partnering with your immigration provider is key, because they'll be able to help navigate some of the challenges that you might face. as they sort of do their due diligence when they're reviewing the documents, to be able to see, hey, these are going to be some of the challenges that you might face, and kind of working with the decision makers and the CEOs who are, more readily able to kind of be more nimble, because there isn't a whole lot of structure yet in place for those companies, and we can help create and plan around what some of that structure could be to kind of get you in that direction. So it's not impossible, but there are absolute challenges. Leverage from those folks that kind of know best and can help you navigate some of the hurdles there.
Yeah, I would just echo what Christy said. Small companies, startup companies have different issues. Definitely doable. We've done many. You just have to address some of those special issues. They get a little more scrutiny from USCIS when you put petitions through. So you just have to overcome that additional scrutiny.
Great. Thank you both for addressing that final question. And with that, we are going to wrap up today's conversation. Addie and Christy, I want to thank you so much for joining us this afternoon.